The second cue that we see in a lot of the literature is if there are sharply differing or divided opinions expressed by the justices on the lower court or between two or more courts in the appeals process. So as this case is making its way up the appellate process, you go from the trial court, whether we're talking about a case that arises under federal law or state law, you have some trial court decision, and then you have some intermediate appellate court decisions. These intermediate appellate courts are typically composed of panels. A trial court is generally presided over by one judge, okay? But appellate courts generally have panels of judges. And it's almost always an odd number, 3, 5, 7, 9, something like that, right? So in deciding the case, if the appellate court has a split decision and the opinions that are issued by the justices on the appellate court are sharply divided on matters of law, then that may send a signal to the court that this is a case that needs resolution. Or by the same token, if you, as you're going up the appellate process, if a higher appellate court is reversing a lower court and there are these sharply divided opinions on matters of law, then that is a similar type of cue. If it is a case that involves a civil liberties or a civil rights dispute, this is true of the current court, really going back to the middle part of the 20th century. So for about the last 70 years or so, the court seems to be particularly interested in civil liberties, civil rights disputes. So if it is a case that raises, like a lot of the stuff that we talked about earlier in the semester, free speech questions, right to privacy questions, criminal due process questions, right to vote, all the sort of things that we talked about for a good chunk of the semester, in the middle part of the semester, those seem to be cases that the current court, again, for about the last 50, 60, 70 years, seems to be mainly interested in. If we go back to an earlier period, say the 1930s, the court didn't seem to be so much interested in civil liberties and civil rights cases. Actually, during that period, it seemed to be more interested in cases that raised questions about congressional regulation of interstate commerce. And if you go back to the 19th century, it was mainly questions of federalism, the division of powers between the national government and the state government. So it could be that in some point in the future, we'll have to replace this with some other type of case. But the current court seems to be mainly interested in civil liberties and civil rights cases. That doesn't mean they do hear other kinds of cases. But if it's a civil liberties or a civil rights case, that seems to be something that really increases the probability that the court will review the case. If it is a case in which the United States government is either a petitioner or respondent, a party to the suit, if the United States government is a party, right? Who's the petitioner? What is that? A petitioning for what? No, we got to be real precise here. Real precise. It's the party to the suit that's petitioning for the writ of certiorari. It's the party that wants the Supreme Court to review the case. So that means that they got an adverse ruling from the lower court, right? If your arguments prevailed at the lower court, you're satisfied. You're not going to ask the Supreme Court to review it at that point. But if you did not prevail at the lower court, you're going to ask the court for a writ of certiorari. Okay? So it's the entity that's asking for the writ of certiorari that's filed the appeal. The respondent obviously is the other party to the suit, and it is convention that the petitioner is listed first, right? So if it's Marbury versus Madison, right? Who was the petitioner? Well, that's a poor example. Let me pick a different one. How about Griswold versus Connecticut? Who's the petitioner? Who's asking for the writ of certiorari? That's the case that involved the law of the state of Connecticut dealing with contraception. Griswold, right, the director of the Planned Parenthood clinic, right, in Connecticut, is the respondent. Miranda versus Arizona, the famous case involving that ultimately led to the Miranda warnings, right? writ of certiorari, and Arizona is the respondent. Well, sometimes you have a case like, Texas versus the United States. Remember that was a case we talked about earlier in the semester that dealt with the dual ballot system in the state of Texas. Okay, obviously the state of Texas is asking for the writ of certiorari, okay? But the United States is the respondent, and sometimes the United States is, the petitioner. Right? So it's the entity that's listed first that's the petitioner. But I guess really the point I'm trying to get to here is that sometimes you have the United States government that is a party to the suit, either as petitioner or respondent, but it's not clear just from the name of the case. Because sometimes it is, the case Missouri versus Holland. Or how about, here's one that you dealt with earlier this semester, McCulloch versus Maryland. Right? Remember that one involving the Bank of the United States? Okay. James McCulloch was the teller of the Bank of the United States, so he's really acting as the agent of the United States government, right? And so it's really a dispute between the government of the United States and the government of the state of Maryland. Okay, so sometimes it's not immediately clear from the title of the case if the United States government is a party to the suit, but whether it's apparent or not, if the U.S. government is a party, then it's going to increase the probability.